Hi there, I'm Professor Blackmore and welcome back to my channel. And today I'm coming back to you with chapter 4 of these testamentary selections in the book of the Gospel according to Bishop Whitehead, honey child. And this will be a follow-up to my prior chapter 2 video, which covers my review of the bankruptcy court case involving the tussle over the church building where Bishop Whitehead is currently conducting his church services. And for all of the Bishop Whitehead haters out there, this is for you, baby boys and baby girls, but you're gonna have to wait so I can lay the proper foundation. Now, if you want to get caught up on all of the information on how we got to this point where we are now in this case, please watch my prior chapter 2 video, because I'm going to pick up this bedtime story on January the 24th, 2023, when the judge of the Kings County Civil Court in New York issued her order ordering that Gloria God be granted possession of the church building by 5 o'clock p.m. on January the 24th, 2023, with the assistance of the NYPD if necessary. But as you know, this never happened because Bishop Whitehead clearly already knew what he was going to do at that particular point in time. And what he did in fact do was to file a Chapter 11 bankruptcy in the United States Bankruptcy Court for the Eastern District of New York at 2:10 p.m. And at that exact moment in time, it stayed all action in the Kings County Civil Court, placing the jurisdiction of the matter now within the purview of the United States Bankruptcy Court, rendering the Kings County Civil Judge's January the 24th, 2023 order and the 5 o'clock p.m. deadline null and void. And so for this reason, Gloria God filed a motion in the bankruptcy court to dismiss the bankruptcy case and a motion for relief from the automatic stay imposed by the bankruptcy court. And the plot thickened even further when the party who owns the property where Bishop Whitehead is currently conducting his church services by the name of Mr. Michael Moses also filed a motion to dismiss the case. And as I stated in my last update on this case, Mr. Moses' filing suffered from a few deficiencies, but it looks like they were able to resolve these deficiencies and the matter was set to be heard by the court on March 1st, 2023. Now, you are aware that I feel that Mr. Moses would lose this motion because this addendum to the 5904 Foster Avenue Trust states, quote, Lamor Whitehead is appointed to act as trustee of the 5904 Foster Avenue Trust with the following limited and restricted grant of authority solely to enable him to perform the following 2 acts. Number 1, to secure financing for him to purchase the real property located at 5904 Foster Avenue, Brooklyn, New York. And number 2, to commence and pursue an appropriate legal proceeding in a court of competent jurisdiction seeking a court order removing the current occupants of the real property, i.e. Gloria God, end quote. So, Mr. Moses wanted Gloria God to be evicted from the church building, and so his interests and the interests of the 5904 Trust are adverse to the interests of Gloria God because clearly Mr. Moses and Bishop Whitehead both wanted Gloria God to be evicted from the property. In addition, whether Mr. Moses likes it or not, he absolutely appointed Bishop Whitehead to act as trustee to take whatever legal action possible to bring about the removal of Gloria God from the church building. And so Bishop Whitehead has absolutely accomplished the task created by the limited grant of authority. And that is because the bankruptcy court is a court of competent jurisdiction, and it absolutely has the authority to evict, glory to God, from the church premises. But the plot thickens even further because Bishop Whitehead's attorney seemed to have failed to appear at the hearing. And so he could not make any of the arguments so eloquently just urged by yours truly. And the judge had no other choice but to grant the motion to dismiss. And I guess it took everybody by surprise because none of the attorneys seem to have had an order prepared to give to the judge to sign. So although the judge granted the motion, there is no operative document on file that can actively dismiss the case. I mean, if you show up to a hearing requesting relief, you should always bring an extra copy of your order for the judge to sign, Mr. Moses and Gloria God, because it seems to me that neither one of them who were both asking for the case to be dismissed did not have an order ready for the judge to sign. Lordy have mercy, y'all. I think people think that judges just sit in their chambers typing up orders, but this is the job of the attorney to prepare a proposed order for the judge to sign so that if the judge grants your motion, he or she can sign and enter the order right then and there. Judges do not prepare orders. Let me just say that again. Judges do not prepare orders on motions that are urged by parties in the case. If they want an order, they will have to prepare an order for the judge to sign. If there's something in the order that the judge doesn't like, they'll strike that part out and then they'll just sign the order. And so, upon realizing his oversight, and with there clearly being no signed order on file granting the motion to dismiss, Bishop Whitehead's attorney quickly filed this motion to vacate the judge's ruling, in which the attorney states, quote, that he failed to properly calendar the initial conference and hearings, that he was consenting to surgery for his mother on March the 1st, 2023, due to burns to 40% of her body, that his mother underwent surgery on March 2nd, 2023 at the University of Florida Hospital in Gainesville, Florida, end quote. Now, the plot thickened even further because on that same day of the hearing on March 1st, 2023, the attorney also filed this amendment to the bankruptcy filing, changing it from a, quote, none of the above, end quote, type of business, Chapter 11 bankruptcy, to a, quote, single asset real estate, Chapter 11 bankruptcy. And so the motion to vacate the judge's ruling granting the motions to dismiss are set to be heard on March 2023. In addition, the bankruptcy trustees creditors meeting was reset to take place on April 14th, 2023. And what we need to understand at this moment in time is that this case is not closed. If it was closed, it would say up at the top of this docket sheet, it would say closed. This case is still wide open. And as you can see here, there are still hearings that are set on the court's docket. And if the case was closed, all of these hearings would have been vacated by now. But as y'all know on here, I just ask and report and I let you decide. So, do you think the judge has had enough of this mess and will deny Bishop Whitehead's motion to vacate her ruling, granting the motions to dismiss? Or do you think the judge will take pity on the attorney due to the unfortunate health crisis suffered by his mother and vacate her ruling, granting the motions to dismiss? I already know what y'all gonna say because y'all just hate this guy. please let me know by leaving your comments in the comment section below. And I hope you'll also give me a big thumbs up. And I hope you'll also consider donating to this video and my entire channel ministry by clicking the super thanks heart button below. And I want to say another note on this note, and that is that YouTube is doing something strange. They're trying to turn themselves into TikTok, and so the effect of what they're doing to channels like mine is demonetizing, and so you'll see less videos on this channel until this is rectified by YouTube. And so if you click and smash that super thanks heart button, it will be much appreciated, and it will help me to continue producing my videos. But that's not it, y'all. I also want to ask that you please subscribe to my YouTube channel and click the bell so you'll be notified whenever I come back with more hot tea on this case. And please also follow me on TikTok and Instagram.